Claim breach of contract, 合同违约. Claim is a legal demand by the non-breaching party of a contract to the breaching party for compensation or payment for the loss caused by breach of contract. 索赔是由非违约方向违约方提出的因合同违约造成的损失要求赔偿的法律要求。The breaching party shall settle the claim according to governing law or customs. Breach of contract is a failure or refusal without a legal excuse to perform or intent to not perform any of a contracting party's obligations that forms or a part of the contract. 合同违约是指无合法理由，合同一方无法履行、拒绝履行或者意图不履行合同规定的全部或部分义务的行为。Breach of contract can be caused by seller. For instance, the seller may fail to deliver the goods or fail to deliver the goods according to shipment date stipulated, or the goods are not in accordance with the contract regarding quality, quantity, and packing, etc. Also, the shipping documents submitted by the seller may be incomplete or inaccurate, which preventing the buyer from collecting the cargo at the destination. Buyers can also cause breach of contract. For example, on the letter of credit, the buyer refused to open the letter of credit or failed to open the letter of credit within the stipulated period. The buyer refused to pay or accept the goods without legitimate reasons, or under the FOB term, the buyer fails to dispatch the vessel. The laws of different countries have their own definitions and regulations on breach of contract. In English law, there are two types of breach of contract: breach of condition and breach of warranty. Condition is the important term of contract, which is regarded as the essence of the contract. If breach of condition occurs, the non-breaching party can terminate the contract and sue for damages. Warranty is defined as a term that is not vital to the overall contract. If only breach of warranty occurs, the non-breaching party can only sue for damages. Under the American law, a material breach is defined as any failure to perform a major part of the contract. The breach is substantial and prevents the contract from being completed or defeats the purpose of the contract. Such breach is substantial. In case of a material breach, the non-breaching party can terminate the contract and sue for damages. A minor breach occurs when a party fails to complete a less serious part of a contract. The contract can still be completed in the event of a minor breach. A minor breach is a partial breach. It is less severe than a material breach. If only the minor breach occurs, the non-breaching party can only sue for damages. According to United Nations Conventions on the International Sale of Goods, Article 25, a fundamental breach is a breach so fundamental that it permits the aggrieved party, 受损方, to terminate performance of the contract. In this case, the purpose of the contract is endangered so seriously that the interest in the contract ceases to exist as the consequences of the breach of the contract. In addition, that party is entitled to sue for damages. But in case of a non-fundamental breach of the contract happens, the aggrieved party can only sue for damages.